time. I want to start by saying a name. I'll get a little closer here. Kate Corman. Kate was an APS customer. She was behind on her electric bill, as many people can be, with the ever-increasing cost of living. Bills pile up, and those living on fixed or low incomes have to choose, oftentimes, what bills to pay in a given month. That's just reality. On May 13th of 2024, Arizona Public Service Company remotely disconnected Kate Corman's power. It was 99 degrees that day. 6 days later, she was found dead in her home. APS has not admitted or agreed to liability or fault through the settlement we are announcing today. But I do not believe that Kate's death had to happen, and that is why we are here today. After Kate was disconnected and after she passed away, my office investigated APS's disconnection practices, and today I am proud to announce that we have reached a settlement that helps hold the utility accountable to its customers and delivers real change for Arizonans. Before I get to the details of the settlement, I want you to hear from the people who matter most in this case. Kate Corman was someone's mother, she was someone's family member, and her sons have something they want to say. They have provided me with the following statement that I'm going to read to you now. This is from Kate Corman's sons, Jonathan and Adam Corman. When we received the terrible call about our mother Kate Corman's death just after Mother's Day in 2024, we were of course devastated. When we arrived at our mom's house, as we both live out of state, the thought didn't even occur to us that our mother's power company would or could disconnect a senior woman's power during such hot temperatures. The day APS cut her power, it was 99 degrees, and it reached 102 degrees in the days that followed. Now, thanks to AG Chris Mays' investigation into our mother's death, APS customers will be better protected with their voluntary 95-degree disconnection threshold. We hope that all Arizona power companies will follow suit with at least this common sense approach to better protect their customers' health and well-being. We still believe legislation is needed for statewide utility disconnect rules so every utility customer is covered. We also encourage families living out of state, away from elderly parents, to learn about the safety net program, which we learned about only after it was too late. Though it is extremely unfortunate our mother had to lose her life for us to see these changes, we're thankful that some everyday people will see some relief this summer and onwards, as it's the best way we can think of to honor our mother's life. And that is why this matters. Now let me tell you what this settlement does. APS has agreed to fund a $1 million consumer assistance program with at least $800,000 going directly as bill credits to APS customers who are behind on their bills and at risk of having their power shut off. That help starts right now, and it runs through September of this year. APS will also pay $2.75 million to the state of Arizona's Consumer Protection Fund, and it comes entirely, all of this money comes entirely from APS shareholders, not from ratepayers. APS will also spend an additional $3.4 million on reforms to how it communicates with and protects its customers, better notifications, better outreach, better tools for people who are struggling to keep up with their bills. But the most important change, the one that could and I believe will save lives this summer and every summer going forward, is this. APS will no longer disconnect power based on the date on the calendar alone. If temperatures are dangerous, the power stays on. For years, APS had a voluntary policy of not disconnecting service when temperatures were forecast to hit 95 degrees or higher. Sadly, they ended that policy 3 days before Kate Corman's power was cut off. Under this settlement, that protection is back, and it is binding. APS must halt residential disconnections for non-payment whenever the temperature at a customer's location is forecast to reach 95 degrees or above the following day. The same protection applies on the cold end of the spectrum. No disconnections when temperatures are forecast to drop to 32 degrees or below. It's important to remember that APS is a very sprawling utility. It serves all throughout portions of Arizona, including in northern Arizona. We are also requiring APS to write to every other major utility in Arizona, SRP, Tucson Electric Power Company, the cooperatives, and all of the electrical districts, and encourage them to adopt the same protections. Because this shouldn't just be an APS policy. It should be the standard across our state. And I want to be direct about something else. It should not have taken a lawsuit by my office to get here. I also think I want to thank actually a couple of you, because it was because of several of your stories, especially you, Joe Dana, that this issue came to light. So it should not have taken a lawsuit by my office and news reports to get us here today, but that is how this happened. The Arizona Corporation Commission regulates APS. The legislature sets the policy environment in which utilities operate, protecting Arizonans from having their power cut off in life-threatening heat is not a novel or complicated idea. It is a basic obligation of utility regulation. And yet here we are with my office having to step in through a consumer fraud investigation to secure protections that the commission and the legislature could have mandated years ago. I am proud of the work my office has done, but make no mistake, this is a gap in oversight that should not exist, and it should not persist. The Commission has the authority to make temperature-based disconnection protections permanent and universal across every utility in this state. The legislature has the authority to write them into law. I am calling on both to act and to codify the protections, these protections into law and regulation. Arizona is one of the hottest states in the country. We all know that. Our summers are not a surprise. Extreme heat is not something that happens once in a while. It is a known, predictable, annual reality that is getting worse. This year we hit triple digits in March. No utility operating in this state should be allowed to cut off someone's power on a 99-degree day because of an unpaid bill. Kate Corman deserved better. APS customers deserve better. And today we are making sure that they get it. So thank you all for being here. I appreciate you, and I'm happy to take your questions now.
I guess the question becomes, okay, they can't cut them off. The bills will continue to accumulate. I appreciate the money you've got in there for some people. At what point do you get to the point where you realize these people can't afford the bill, and all you've done is put it off? I don't know whether they can they charge interest? I mean, are we just deferring the inevitable perhaps to September?
Well, look, my view is it's better to be alive than to owe a bill. I mean, you know, at least you're alive to be able to pay off that bill down the road. And so, you know, I know that this is a debate in the utility and regulation space, but I don't think it should be a debate, Howard. I think it is obvious to me that the utilities have an obligation to, at a minimum, keep their customers alive. And it is getting hotter and hotter earlier and earlier in the year. And the policy that the utilities have selected, which is a calendar-based approach, is just not adequate to protect utility customers from potential death. And that is what happened in this case. Heat, according to the medical examiner, did contribute to Kate Corman's death, and she died in her home after APS disconnected the service. Now, so, you know, we want to prevent that from happening again. We want to make look, it was 100 to 105 degrees in March this year. I mean, next year it could be February where it hits these temperatures. And it's just important for the utilities to go back to that policy that they themselves, for multiple, well, APS at least, for I believe up to 3 years, was voluntarily living by, which is a 95-degree hold policy. Joe?
If you don't mind, 3 quick questions. First, APS did tell us they made APS says they made 10 communications with Corman after she stopped paying her bill in January 2024, and those attempts included leaving a door hanger notice at her home. There was no known evidence of the door hanger, but APS says 10 attempts. Did your investigation find that was the case, and did you find any other evidence that APS didn't follow their own protocols?
So, I mean, I don't think this was about whether their own protocols, whether they followed their own protocols. It was about whether their protocols are adequate to keeping people alive in the summertime. And one of the things that are in this settlement, and I apologize, I forgot to recognize John Dillon, who is standing with me here, and he can probably help me answer this question, and Felicia Rodolini, who helped get this case across the line. You know, we have included in this settlement a number of improvements to APS's safety net program, including making sure that the safety net program itself is more of an emergency alert system, where the person that is designated as your emergency contact gets text messages and emails, and that person is alerted by text message, and that also APS has agreed to increase its efforts to get people on the safety net program by pop-up ads and improvements to its website. So we're trying to get more people on that safety net program so that more family members can be alerted to a problem that their mom could be having. If I'm not mistaken, Kate Corman was more than 80 years old. Yeah, so we're talking about a woman who was more than 80 years old. I actually had a Zoom call with her sons last night, and they relayed to me that their mom was on an auto pay program, and she was kicked off of that auto pay program, I think because of a non-payment issue. And then they believe she thought she was going to be put back on the auto pay program, and she didn't get put back on that auto pay program. So could have been a lot of reasons that she didn't get the notification. The bottom line is, even if you get the notifications, you shouldn't have to die because your utility disconnects you when it's hot in Arizona.
And second, it required a heat activist, unpaid, to sort of initially find this data and bring it to us.
Well, Joe, I mean, that's a really great question. I think that I'm not an expert on heat death reports, and but from what I know, it seems like we should be getting the public, you as journalists, maybe even my office, should be getting more information and more quickly from the counties about heat-related deaths, so that we can know what's happening. I'm going to give you some numbers. This is really interesting, and you guys can fact check me on this, but yeah, I believe the Corporation Commission requires the utilities to put on their website the number of disconnections that they do every year. And even in, and when they do them, and even in, try to find this, even in 2024, here we go. In 2024, APS disconnected 3,205 people in April. In May, they disconnected 2,208 people, and in June, they accidentally disconnected one person. So that's a lot of people. That's 5,400 people who were disconnected just in 2024 in some really hot months. That's why this change by APS back to the 95-degree line is so important, so that even when it is hot, people aren't disconnected.
And third, did your investigation look at APS's cooperation with the Arizona Corporation Commission? Because I know they investigated this as well. And did you find anything there?
So we did ask for all of the data and information that was given to the Corporation Commission by APS during its investigation. What I would say is that our investigation was much more complete than theirs, and I'll leave it at that.
Did you have reason to believe that APS withheld information from the Corporation Commission?
No, I just have reason to believe that maybe the Corporation Commission didn't do a good job with its investigation.
So you've gone after APS. Did you investigate TEP, Unisource, SRP, who also have disconnection policies? I know APS is a wonderful target, but have you done investigations into the other utilities?
So we haven't seen deaths into those, or deaths occur at those other utilities yet. I believe it's only a matter of time before a heat-related death occurs at TEP and Unisource Electric and SRP, because their policies in some cases are even are even worse than APS's was. SRP's is, I believe, June and July only. I mean, they do disconnections, or that's when they can't do disconnections.
We also talked about periods of high alerts, but I guess the question is, I appreciate what you're saying, there's no deaths. You're looking at policies.
No,
why haven't you looked?
Well, we are. I mean, trust me, we certainly are, and that is why one of the things that I insisted upon as part of this settlement agreement, Howie, is that the CEO of APS contact his colleagues at TEP, SRP, and the other utilities, and urge them to follow suit. But what I would say is those utilities that are not following the 95-degree hold policy are on notice. They are on notice that anything other than 95 degrees is dangerous and can kill people. And if somebody dies on their watch with a date-based policy, we're coming after them too. So if I were them, I would switch immediately. They don't need the Corporation Commission's approval to do that. But I would also go to the Corporation Commission and ask for the policy to be changed.
Attorney General, temperatures go up and temperatures go down.
We'll come right back.
Is this also going to require people to get their power turned back on when they've been disconnected, and temperatures go back up again?
Can you say it again? Sorry, I didn't
Let's say
understand.
the temperatures drop to 85 degrees.
Yeah.
They come back up to 95. Is someone who's been disconnected for non-payment now going to be reconnected because the temperatures are dangerous and it's hot and people could die?
Well, I mean, the policy is that if they cannot be disconnected if it's, if it is hotter than 95 degrees, period.
But
And
I think
so-
the point of this question is, my power's disconnected, is 85 degrees, I didn't pay my SRP.
Yeah.
Or let's say APS bill.
Mm-hmm.
Okay, my power's disconnected, I'm sitting there, temperature gets to 96. Do they have to then come out and reconnect me because it's now above 85 because I've been disconnected below?
I mean, I think that's a good question. John, I don't know if you want to handle that, but
Sure. Yeah, my name is John Dillon. I'm a
Come
senior.
on down.
Yeah, thank you.
If it doesn't occur in the microphone, it didn't occur.
Yeah, my name is John Dillon. I'm senior litigation counsel here at the Arizona Attorney General's office. So what the consent judgment does and our settlement does is it does prohibit the termination when it's 95 degrees or higher, both that day and the following day. I think a practical effect of that would be that when the temperature lowers, I would imagine that moratorium is now not on the table and power could be turned off at that point. We believe that APS negotiated in good faith with this, and they're aware of the risk that are involved in extreme heat. And so, we think that they will continue to monitor the risk and the potential danger, and make sure that something like what happened previously doesn't happen again.
It still doesn't answer the question. Permission to treat the council as hostile. It still doesn't answer the question that was asked. If my power is disconnected when it's 85, let's assume it's not March like this year.
Mhm.
Power disconnected, 4 days later, and they follow the policy, 4 days later, it goes up to 98.
Mhm.
I'm disconnected because of power. Does the utility, under the terms of this, have to reconnect my power because it's now
would have to.
too hot?
Yeah, two things, I don't know, well, do you want to answer?
Yeah,
that?
again, how I would answer your question is to relay what the consent judgment provides for, okay? And what the consent judgment provides for is that when it is 95 degrees or higher, and it's forecasted to be that the following day, that is when the moratorium would be in place.
And the
If the-
power couldn't be off.
Right, and so if we're dealing with the summertime moratorium, which is also in place, the power will not be shut off. If,
But then, so,
Just to be clear, then, it sounds like it's related to shut-offs, but it doesn't relate to turn back on.
Yeah, that's my question.
Well,
That's-
It doesn't
well-
require them to turn
yeah,
it down.
and the other thing too I would say is that with the credit program that they've adopted, there will be, or presumably will be, consumers who their bill will be paid, or they'll be credited. So it won't be an issue anymore, just given with that.
So, look, I mean, my interpretation is, yes, they would have to turn it back on. Now, if we end up with a disagreement after the fact with APS about this point, we'll come back and talk to you about that. And there are elements of this settlement agreement that require a lot of interaction between my office and APS going forward. So we're going to be auditing, for instance, elements of their programmatic improvements. And so we'll if I'm wrong about that, we'll have some conversations about that. Yes.
Talk about customers who are eligible for that $800 credit. What is the eligibility and how would they, would it be automatic? How would they go about getting it?
So great question. So the $800,000 that we negotiated will go to individuals. Let me try to find my place there. It will go to folks who are behind on their bills and who are in danger of being cut off of electricity or likely been cut off. Hang on, we'll come back, Howard.
I want to hear the financials part of that, whether there's an eligibility requirement income-wise.
No, I mean, it's, at this point, no. But what I would say is there's also an agreement that APS will look at the most vulnerable customers. So I don't know if they actually have income information. I don't think they do. I don't think they have income information. But it's people who are in danger of being cut off, who are most vulnerable. They've got a lot of information about people who have been in arrears in the past. And so those are the kinds of factors that'll play in. So it's $800,000. We're hoping this will bring, a number of people, a lot of people, as many people as possible, back up to a place where they're not in danger of having their power cut off.
A number of how many people are in that danger right now? Because you said it starts today.
Yeah, we can get that for you. I think we do have that probably somewhere we can get it. Yeah, we'll get it for you.
Question about different topic?
Sure. Joe,
There's more
Wayne.
questions on this.
Oh, Wayne, that was one.
Another-
No,
Let's go to some people who haven't asked.
I have off
yet.
topic as well.
Okay, well.
Yeah, off topic?
Yeah.
Okay.
I was wondering if you have any, if you've seen the letter from the U.S. Attorney to President Peterson in response to his request to investigate you as the Secretary of State, and what your reaction is to the content of that letter, which seems pretty amiable to the Senate President.
Oh, yeah, I was going to say to who. So you're talking about the U.S. Attorney's letter?
Yes.
Okay. A lot of letters flying around. Yeah. I saw the letter, and what I would say about it is that it's all nonsense. There is nothing about the 2020 election to investigate. Let me repeat that. There is nothing about the 2020 election to investigate. I mean, let's remember, it was this office under my predecessor that sent, huge portions of our special investigations section out to investigate the 2020 election. We spent 10,000 man and woman hours investigating the 2020 election and came up with zero fraud. So here they go again, is what I would say. And I don't know why they're so obsessed with 2020, except it seems like they just can't get over that. Weird, because then, President Trump won in 2024 in what was yet again a free, fair, and secure election, as we always have in the state of Arizona. But here they go again. Look, I would just say this, Wayne, also, this is a U.S. attorney alongside a candidate for this office who is trying desperately to curry favor with Donald Trump as he comes to town on Friday, where he'll undoubtedly continue to lie about his loss in Arizona 6 years ago. So we have too many important things to focus on in this office, other than these publicity stunts. And like what we just talked about today, which is going to save people's lives. I'm going to keep focusing on the things that matter to Arizonans. I'm going to keep focusing on protecting Arizonans and going after fraud and going after criminals. But, I guess that's what I would say. And then the last thing I'll say on that point is we are going to run another free and fair election in the state of Arizona in 2026. And we're going to protect the privacy. We're going to protect the privacy of Arizona voters in accordance with the law, no matter what the Trump administration tries to do.
Can you respond just generally to the Senate President's allegation that he believes there's evidence your office and the Hillary Fontes may have done something to obstruct justice and witness tampering? In terms of the conduct of your office or staff members?
Again, Joe, it's utter nonsense. I think the Senate President is demonstrating the fact that he's only been out of law school for 2 years. And I'll leave it at that.
Okay, a couple more.
Sure, yeah.
So the state constitution prohibits sitting lawmakers from seemingly holding any other office during the term to which they were elected. Do you have any legal concerns with the fact that the Navajo County Board of Supervisors just appointed Representative Dick Marshall to the next report?
Yeah, so what I would say about that is we're taking a look at it. I'm going to reserve any additional comments on it because it's possible that could end up at our office. So we're taking a look at it. Yeah.
Warrant to action, I assume, if you find
We're not gonna prejudge anything right now, Howard. I know.
Come on.
Again, you should have gone to law school. What the, we've talked about this before, but
It's much more fun being on my side.
I know, I know, I used to be there. Okay, go ahead.
I just wanted to ask for an update on the public monies investigation into the Department of Education regarding the ESA program.
Yeah, so it's still ongoing, and we continue to do that investigation. I don't want to put a timetable on that, but I continue to be very concerned about the evidence that continues to come out. Some of it from reporters in this room, showing that ESA voucher money is being used for things like diamond rings, lingerie, flat screen TVs, and condoms. Can't believe I'm saying that right from the podium here, but that's where we're at with the ESA program. It's totally unacceptable for taxpayer money to be misspent like this, and it needs to stop. It needs to end. Yeah.
Can you give us your reaction to the reporting that Justin Heath was coordinating a correspondence with the DOJ?
Yeah. I guess what I would say, I don't know what Justin Heap, what fraud Justin Heap thinks he's going to find. I don't know why he would collaborate with folks in Washington, D.C. to look again at a 2020 election. And if Justin Heap has evidence of fraud, which I'm fairly certain he doesn't have, then he's required by state law to report it to this office. He is required, again, let me repeat that. Justin Heap is required by law to report any allegations of fraud to this office, and he has not done that. Okay? All right, thank you guys. Appreciate you being here.